Hello everyone. I hope everyone's having a good day here at Lab Innovations. My name's Rich Wells and I'm going to be talking about intellectual property and how you help identify it in your business. So I'm going to start off talking a bit about what is IP, and I'm going to focus on patents in particular. I'm a patent attorney, so that's my speciality. Then I'm going to be talking to you about what you can do to make your workplace a bit more IP savvy, whether you're an innovator yourself or whether you work with other innovators. So my aims really are to help raise a bit of awareness about IP and then help to, allow you to understand what you can do within your workplace. So let's start off with a good dictionary definition of, what is IP? It's quite broad really, so this is what the World Intellectual Property Organization says it is. It's basically anything to do with the creations of the mind, be it inventions, designs, artistic works, names. So it's all fairly broad. And as an IP specialist who helps people protect their innovation, I think that this can have impact or can be found in most parts of your business. So as an example here, we've got an inhaler. So this is a product. Could have various different components. You could have the drug itself, you could have the look of the device, the brand under which you sell your product, and even the instructions that will tell the user how they use your product. Now, each of these can lead to the generation of different types of intellectual property, all of which can be protected by different types of IP right. So, for example, the drug could be protected by a patent right, the look of the device could be protected by a design right, the name or brand, sort of the brand in general, logos, etc., could be protected by a trademark, which some of you might have heard of, and the set of instructions could be protected by copyright. So why bother with IP? IP can be found in different parts of your product and different parts of your business, but why bother? It essentially helps you to protect your innovation. So you, as an innovator or your company, have put a lot of hard work and money into developing your innovation. So it's important that you protect it. And having an IP right will help you stop others from essentially copying or using your invention. And this helps to establish and maintain a unique selling point, which obviously will help you to charge a premium for your product if other people can't copy it, can't replicate it. So essentially it creates value in your business, and this can also help generate investment. Investors, they're looking at your business, want to know whether what they're investing in is the only thing like it on the market, and having IP behind your company, so these rights that stop others from copying you, can reassure investors that you do have that position. So I talked a bit about generating value in IP. So how can you generate value in IP? In essence, intellectual property can be viewed almost like physical property rights. They can be bought, sold, and they can also be lent or licensed. And this allows you to generate income within your company just above and beyond being able to charge a premium for your product based on having a sort of unique selling point, this prominent position in the market. And this is something that a lot of companies often do to generate such income. An example, say, with a license, as I'll go on to talk about later, different types of IP, such as patents, are jurisdiction specific, so you can have them in different countries. Say you're operating primarily in the UK, you're selling your product in the UK, that's your market. You might not be so worried about markets elsewhere. Say you've also got IP in Spain, and a competitor or a company wants to do something similar to your invention, you can then license them your IP in that country, and that will create an income stream from Spain which you wouldn't necessarily otherwise have if you just choosing to sell your product, provide your service within the UK. So what are patents? As I said, I'm going to focus on these, largely because I think a lot of people in here, the innovators, the companies, will be generating the type of IP that would be protected by a patent as an IP right. So in essence, they protect technical innovations. They have a 20-year duration, and generally speaking, there can be some extensions for, say, drugs that need to go through some element of regulatory approval. As I mentioned earlier, they're country specific and they need to be registered, so you need to apply for a patent at a patent office. And I'm going to talk a bit about that process later and how you can make your company IP savvy in relation to avoiding pitfalls with the patenting process. So what do I mean by technical innovations? So as many people probably imagine and people know, they can be products within sort of the biology world, the lab world. It can be things like drugs, formulations, devices, even microbes and kits containing your product. As well as that, you can also get patents to methods, such as the method of producing something, whether it be a formulation, a drug, a device, or methods of diagnosing or providing a prognosis for a disease. All these things can be patented. So even if you maybe don't consider yourself an innovator, if you are developing improved methods, that could be something that could attract a patent right. It's also possible to get patents for uses. An example sort of in the world of biology is called a second medical use. So this is a new use, so a new medical use of a known product, and it is possible, even though, well, a known drug, even if that drug is known, you can still get a patent for that. So what do you need to get a patent? So I think giving a bit of background on this can be useful to allow you to understand what the process is and then how you can develop a system within your company, or if you're an innovator, how you can spot IP, in particular IPs that attract patent rights within your workplace. So, as I mentioned, you need to apply to a patent office, and as a 20-year duration, this 20-year monopoly is quite an extensive right. Patent offices don't generally like to give them out easily, so in order to get a patent, it will be examined, your application will be examined by the patent office, and it will need to pass certain legal hurdles before it can be granted, and only when it's granted will it become a right that you can then effectively use to stop someone else copying your invention. Some of these legal requirements, it's got to be novel and inventive, and it's got to be sufficiently disclosed and supported. Now these are quite IP jargon terms, and I'm now going to go into a bit more detail about what that means and how you can develop a system to avoid pitfalls with trying to cross these legal hurdles. So novelty basically means it's not being publicly disclosed before the date on which you filed your patent application at the patent office. And in our speak, anything that's published before that date is prior art. Now these disclosures can be any kind of public disclosure. As you might imagine, it can be quite formal documents such as scientific articles, but it can also be more informal disclosures such as websites, press releases, or even talks at a conference. So it's very important to protect your invention, not publicly disclose it before you file your patent application. Now the fact that the sort of legal hurdle of it having to be inventive, this is slightly more of a grey area, slightly more arguable, and to sort of distill it down to the basics, essentially the novel bit of your patent can't be arbitrary. You've got to have had some sort of technical innovation, it's called a technical effect of your invention to be able to say it's inventive. An example, or some examples of this, is say a known cancer drug, this is the second medical use as I mentioned earlier, which surprisingly treats, say, a neurological disease. This is new and it wouldn't be expected. There's some sort of technical effect. It treats something that hadn't been thought of before. Another example, say a method, a bacterial transformation with fewer steps. Again, there's a technical effect here. There's fewer steps. Maybe it's quicker, maybe it's easier. Again, this might be something that could be considered novel and inventive. Also, say a modified method of diagnosing a particular disease. Say that's more rapid. If this hasn't been known before, this increased speed will hopefully help get results to patients quicker, and that's beneficial. There's a technical effect there. So how can you as innovators, or if you work with innovators, how can you help them from essentially not running into any issues with overcoming these novelty and inventive step hurdles when filing a patent application at the patent office? It's really important to remember that the inventor's own disclosures in practice are also problematic. There's a few exceptions, but generally speaking, patent offices will hold their inventor's own disclosures against them. So research scientists may have been talking at a conference the day before you file your patent application. If the patent office becomes aware of that, they can say, well, that leads to your invention not being new based on your inventor's own disclosure. So when you're developing a system, it's very important that you keep track of when you or your company or your colleagues are going to make these public disclosures, and try and get some sort of system to record those and make sure that you look for IP within your workplace before such disclosures go ahead. So it's really important essentially to engage with the innovators, these people who will be the inventors of the patent. Important, this is also educating the innovators, not only on things like novelty, but inventive step. I've talked in quite general terms about how with inventive step it's got to be just more than, say, an arbitrary development. But in our experience, a lot of innovators, inventors are quite humble. They don't necessarily think what they've done is particularly special. So it's important to talk to them, to really ask them, well, have you done something that's particularly special? You know, is this something that was surprising, say? And try and educate them, maybe in what novelty and inventive step means, to try and make sure that you can capture the IP for what it is before it's disclosed. So incentive, and it's in essence, just to put in place some sort of system, whether that be regular meetings or just, as I mentioned earlier, some way of recording when public disclosures will happen. Another thing that some companies I work with do is incentivize their inventors, the innovators, by providing bonuses if they have patents that are granted or if they file patent applications. And this isn't right for every company, it doesn't work within every system. But in our experience, companies that do put those sorts of things in place do generally have a better level of engagement between the inventors and, say, the patent attorneys they work with. So just an example of the fact that this prior art can come from anywhere. It's obviously not from lab space, it's sort of a lab environment, but this is a UK patent application to a doggy doorbell, and the UK Patent Office said that it wasn't novel over the Beano, and so refused to grant the patent in this way. So the prior art can come from any kind of location, so be aware of what you're disclosing. So support and sufficiency. These are two of the hurdles I mentioned earlier, and again, distilling it down, it's basically, you know, have you got evidence that could be put into your patent application to show your invention works? Generally, it's got to be just, is it plausible your invention works based on the evidence that you've got? Part of this is how much you can generalize what you want to protect within your patent from the data. As some of you might know, patents don't purely cover what you've shown. You can have a bit of what we call scope. You can protect something outside that data. And how well you can do that generally comes from how far you can generalize the data. So it's important to get a handle on what data you have before you file a patent application. And it could be less than you think. Most of our clients pretty much base patent applications, say, on a scientific article, a manuscript's worth. For example, if you want to get a patent for a drug, generally in vivo animal testing isn't always needed. You can sometimes get patents granted based on in vitro data, which shows that your drug, your compound, works within a disease-relevant system. It's also worth thinking, if you're an innovator, if you're working with innovators, what other fairly simple experiments you can do to try and provide extra data for the patent application. This might be uninteresting if you're an innovator, but could provide reassurance to a patent office that actually your system that you want to get a patent for, maybe the drug you want to use, is robust. For example, using testing a compound against different types of cells, or testing the robustness of different variables within a method that you want to protect. So based on these general discussions of the system and with a bit of an explanation of what these legal hurdles are, we're thinking, well, what are the common pitfalls? You know, how can a system help? And I've used quite a sort of rather binary traffic light system here of sort of red as you might have a problem and amber, well, it's something to think on. So have you done something that's new? Is it novel? If there's a clear public disclosure, at least for a patent, it might be quite difficult to get that granted at a patent office, and it might be not worth thinking about filing a patent application. If you think what you've done is new, how routine really is it? Is it inventive? Now, as I said, this is a grey area, so I don't think it's ever a cause to sort of really roll back and not proceed with the patent process, but it's worth thinking about it. Similarly, how much data have you got? have you got enough data to maybe put in a manuscript? Is what you want to say your invention is plausible from that data? One thing I've not mentioned yet, but is often a bit of a prickly sort of thing, is ownership. And that can be an issue. So you'll file a patent application in, say, the name of a company, you'll profess to own the invention. If another company, say another part of the collaboration, thinks that they should also be named, they can challenge this ownership at court, which can obviously cause complications later and can increase costs. Also, as time goes on, products become more valuable, the stakes can be higher. So we often suggest that ownership issues are dealt with quite early doors. You know, that can include, if you're in a collaboration, looking at that collaboration agreement just to see how IP is dealt with, who owns what. And lastly, this is sort of quite a general point, but it's always worth considering. The patenting process can be expensive. The expense depends on how ambitious, how many countries you want to go into. But it's not something to necessarily be taken on lightly. And having a granted patent, even though you'll have a unique position in the market, hopefully based on the monopoly it can provide, it doesn't guarantee commercial success. So it's very important, I think, to make sure that what your patent is meant to cover, the product, actually supports the commercial goals of your business. Now, how can the professionals, such as patent attorneys like myself, help? We can kind of be involved from day one to help you, advise you on the strategy. We can help analyse what IP you've generated, if it's a patentable invention, whether it's new, whether it might be inventive, have you got enough data? Also, may there be any ownership issues, and if there are, how can we help you to resolve them? We can help you prepare the application. They are quite complex legal documents, and once the patent application is filed at the Patent Office, it can't be changed. So you need to put various information in there that you might rely on in future, and that takes a bit of experience. We can help you with that. As I mentioned, patent applications will be filed in different countries, and there'll be an element of coordinating the prosecution, so trying to get these patents to grant in these different countries, and we can help you with that, working with networks of local attorneys. And we can also help you get granted rights by arguing with the patent officers on your behalf that you should get something granted. Lastly, we could help deal with any third-party issues, and that's sort of what I want to briefly talk about towards the end of my talk now. And that is what a patent doesn't give you. So it's a negative right. It means you can stop someone else from doing something, but it doesn't give you freedom to operate. It doesn't act as a defence if you infringe someone else's patent. An example here of how you can get overlapping patents and where freedom to operate can be an issue is, say, Company A has a very general patent to aspirin. This protects the company or allows them to stop others from making aspirin, using it, treating people with aspirin. However, Company B discovered that aspirin can be used, say, to treat Parkinson's. No one knew this. It's new, it's inventive. This is something that can be patentable. But what that protection does, it lands them straight within what we'd say is the scope of Company A's patent. And that in essence means that neither Company A nor Company B can use aspirin to treat Parkinson's without agreement from the other. So this is an example. Even though both companies have a patent, they'll need some sort of agreement in order to proceed to, say, treat a patient with Parkinson's with aspirin without infringing each other's patent. And this is a situation where licensing, so lending each other your patent rights, can help to try and avoid issues down the line. So to summarise, I just want to outline maybe what a good system could be to avoid these pitfalls, particularly if you want to patent, but they could be relevant to other types of IP. Firstly, audit. What IP does your company already have? Have you got innovations that you've not identified that could be protected using some form of IP, whether that be a patent right, a design right, a trademark, or even might be protected by copyright? Then always revisit what IP is generated. If you've got any element of innovation, what are your scientists coming up with? Is that something that's generated new IP that you might want to protect? Then analyse, based on this analysis of what IP has been generated, are there any pitfalls? Could complications later be avoided? You know, what have you done? Is what you've done novel, inventive? Have you got enough data? Those sorts of things. And then last to act, to apply for the suitable IP at a patent office and get people like myself, such as patent attorneys, involved in your workplace to try and help you in this process. So I hope the take home is, I hope I managed to raise a bit of IP awareness amongst you and hopefully give you some ideas to help you establish a system to capture IP within your work, within your workplace. So with that, I'll open up to any questions. I'll be around later if people want to come and see me to talk to me. That's completely fine. But thank you for your attention.